I think we got disconnected, but I'm back again. I just want to make sure. One second. We good, Countess? You should be back up and running. Go back to the source. Okay, that's good. Countess Cersei, are we there? Are you there? We good? All right, that's what's up. All right. Okay, so we understand based off the McRaney and as the appellant and the Southern Baptist Convention of North America in their SBC doctrine clearly shows that they have the right and autonomy to deal with their own affairs, dealing with their religious autonomy and their religious presumption of what they call ecclesiastical government, which deals with spookism. All right. And that's what's keeping our people in spookism protection by some spook God. You know what I'm saying? Where the true God given good law, because Jesus said, I didn't come to change the law, I came to fulfill the law. So if Jesus reincarnated to fulfill the law, then if that is the case, then I must be the reincarnation of King Edgar the Peaceful, who instilled the law for the English church as a result of the English Benedictine Reformation that he did in the 9th century, as a result of us being converted like we're being done now, a second time to some paganism religion that we know nothing about. Okay? I love how I just said that. That was beautiful. Okay, let's move forward. This is from the circuit court judges. We know circuit court judges are um, district circuit court judges are courts that on the federal level. Okay, this is a courts on the federal level that deals with appeals. All right, and which can be petitioned for certification or written circular to Supreme Court, which usurp the prerogative of the crown. That's my power. When you got a problem with government, you're supposed to come to me. You know what I'm saying? And I'm supposed to issue the writ of prohibition or the writ of mandamus or writ of court warrant to tell them to stop from doing something they're not supposed to do. All right? Let's get there. So it says Supreme Court has told us that the judiciary power of the United States now that extend to ministerial dispute. This case should end with the straightforward application of that doctrine. Okay, let's get there. I'm boastful, but I have to because a lot of people have to claim to be boastful, but they're boasting about nothing. All right. As I always start with the Constitution, original public meaning, the ecclesiastical autonomy doctrine has a rich historical pedigree, and that history informing the meaning of the Constitution and its religious clauses at the founding. So we're going back to the original origin of the reason for the First Amendment autonomy doctrine, which has everything to do with state. Okay, because we know under the Crown, under the Jersey Provincial Council in 1776, it was the fusion of government between the executive, the legislative, judicial, and that was governed by the Crown, which is perpetual. It's still perpetual. Even if there is no king there, God is still doing this thing. The spookism aspect of what we call God. All right? The workings of God, the mystical God, or the mysticism of God. Go back to body of politics. I already broke that down in my last lesson. So if you don't believe it, let's see it for ourselves. All right? This is a 20. Let's see what case is this. What year this is. 2020, y'all. If you don't believe I'm who I say I am, you better go ask these courts. In the Middle Ages, you hear this? Clergy were categorically exempt from the reach of the civil courts. See Felix Makeover of the Constitutional History and Constitution of the Church of England. All right? We already know what the Church of England is. All right? We know what the English Church is because through the Benedictine Monastic Reform, through our Jesus Christ, King Edgar people, become the reincarnation of, as a result of the English Benedictine English Reformation done by Henry VIII, who usurped our state by right of conquest, as we see in regards to the House of Tudors. All right? And now they're tutoring you while there are churches that were established. All right? During the reign of the Saxon kings, civil courts had no jurisdiction over clergy accused of even clear secular crimes until the bishop divested them of their spiritual authority. All right? That will be Archbishop. If a priest allow of a illicit intercourse or neglect the baptism of a sick person or be drunk to the degree that he cannot do it, let him abstain from his ministry until the doom of this bishop. See, this is the Roman Catholic teachings, all right? This is what's within the Catholic Church, all right? And this is why they got the restraints. The people denounced anything and wanted us to practice celibacy, all right? Abstinence, refraining, all right? If a priest killed another man, let the bishop circumcise himself and let him be given up from his ministry. All right, this is why we had Benedictine monasteries, which were based on monks going in exile. I'm exiled. I stay in my house 24/7 by myself with my canine. All right? My queen goes to work, come home. This is all I do. Why? Because this is all the monks did, right? And I set the standard for the monks in my former day as King Edgar the Peaceful. Why? Because we see it right here. Let's read it for ourselves. Edward and Guthrum in a 2020 case law, y'all, the 5th District Circuit Court of Alabama, a territory that our ancestors are well known from being at. All right. This territory was under the Treaty of Paris that was ceded to the United States in 1763 by the Treaty of Paris, when France, which goes falls under what? The Plantagenet crown under Godfrey V Caravan Jew, which I'm showing you in the next case, dealing with due process of law and a right to a trial by jury in lieu of your own peers. Right? It said, Edward and Guthrum, force in Section 2, 906, if a priest commits a crime worthy of death, he should be seized and kept until the bishop of judgment. And during the reign of King Edgar the Peaceful, our Jesus Christ, y'all. Let's get an applause. Give a hand of applause for the court, the Fifth Circuit Court. You know what I'm saying? They gotta be watching our lectures. They gotta be watching, because this is a 2020 case. That's when we first established the English Third Temple Church in 2020. And they talking about this myth, King Edgar the Peaceful, who happened to look just like me. If a priest commits a crime worthy of death, he should be seized and kept until the bishop of judgment. And during the reign of King Edgar the Peaceful, the church required all disputes between clergymen to be addressed before bishops and not secular courts. All right? Not secular courts. Makeover, Supra at 389. Spiritual supervisors retain exclusive competence to discipline clergy, and civil courts could not intervene in church matters. Now remember, secular courts are not the courts dealing with the courts established by the King's Bench, all right, which goes back to the 12th century, all right? So when it stood from the King's Bench, which was King and Parliament, you got the King's Bench, which stems from what we call the Career Regents. Career Regents derived from Witten, go all the way back to the Kings of Wessex, okay, which means wise, what was it? Witten, wise elders or something like that. Don't quote me. The church exclusive jurisdiction over clergy. We're talking about our Jesus Christ, King Edgar the Peaceful, which is being represented in case law in 2023, which I'm the reincarnation of. So in lieu of our autonomy as a government, not the government established by the Church of England when Thomas Jefferson separated the body of politics, i.e. the corporation soul, from the body, i.e. you, because we all make up the body. All right? So during the reign and now in the reign of me, King Edgar the Reincarnated, the church required all disputes between all clergymen to be addressed before the bishops and not secular court. Spiritual supervisors retained exclusive competence to discipline clergy, and civil courts could not intervene in church matters. Okay? The church exclusive jurisdiction over clergy served as a one-way jurisdictional boundary. Although civil courts were powerless to interfere with the matters affecting clergy or other ministerial prerogatives, key word, to interfere with the matters affecting clergy or other ministerial prerogatives. You said it twice. I read that twice. Again. Although civil courts were powerless to interfere with the matters affecting clergy or other ministerial prerogatives, religious authorities extended their power into operation of civil courts in a variety of ways. You see how we switch? We went from ministerial to civil court, i.e. the King's Bench. For example, ecclesiastical leaders served alongside high civil officials on civil courts. King Edgar, once again, mandated that the bishop of the shire, i.e. county, and the aldermen sit together as a civil judicial body empowered to apply both the law of God and the secular law. Edgar the Third, c. 5th. Thus, while civil officials had no role in ecclesiastical matter, ecclesiastical officials adjudicated both sectarian and secular matters. Did y'all see that? Did y'all see that? Another hand of applause. Wise out. Thank you. I heard for you a minute. Give me a second. I got it. Oh man, my brother with the Honorable Bay. Oh man. See, man, when we don't talk, man, I forget. Don't tell me I gotta get this. Call Judah. I got you. I got you there. Call Judah. I got you, Call Judah. Geronimo Bay. Let's get there. All right. One step is the English church from the Norman conquest to the ascension of Edward the First, y'all. The War of the Roses. We're going back to the War of the Roses, y'all. Okay? The Norman conquest further solidified the divide. Around 1076, King William I issued an ordinance formally divesting civil courts of subject matter jurisdiction over religious matter. Ordinance of William the Conqueror separating the spiritual and the temporal. No bishop shall bring before judgment a secular men any case where it pertains to the rule of souls. William Stubbs, The Constitutional History of England and the Origins of the Development. The ordinance established separate ecclesiastical courts to find support at 49. As a result, bishops and other clergy were granted exclusive jurisdiction over all cases pertaining to the rule of the souls. So if you're concerned about your souls, you better come home. Y'all better come home. Over the next several centuries, the civil ecclesiastical courts continued to dispute the boundaries of their respective jurisdictions. The courts each strived to extend their competence to reach additional categories of cases claimed by the other. In their struggle, lay courts employed new weapons while the clergy resorted to the old. For example, the clergy threatened to excommunicate civil judges who infringed ecclesiastical jurisdiction, while the civil courts issued writs of prohibition. Writs of prohibitions were injunctive. Did you hear that? Writs of prohibition were injunctive. Blackstone describes them as necessary to secure the jurisdiction of the king's bench over secular controversy. We know New Jersey under Villain versus Harris, the Supreme Court of New Jersey was inherited with with the king's bench authority, which the legislature was powerless to separate, to sever, to divest. You hear me? That power is still there. I got a letter right now from the Supreme Court, which I issued a writ of mandamus, and as a result of that order from me, a writ of mandamus, they talking about, King, you're absolutely right. We don't have that authority anymore. The 1947 civil judges did away with it as a result of the complexities and technicality of the prerogatives that you have as a part of your jury regalia. As a result of that, what they say in Villain versus Harris, they what they say, they severed the procedural necessities. All right, they done away with the procedural necessities of the writ of mandamus, which is in the court of law, which is in the Supreme Court of the state of the United States. It's not a petitioner right. It's discretionary. It's discretionary, but under Chisholm versus Georgia, under United States of Keefe, a petition of right to the king is a must. All right? It's a must. King's bench deals with the courts of common pleas and the courts of exchequer or courts of chancery. Outside of that, contrast to what we call the Star Chamber, which is a violation of the Fifth Amendment because you have a right to not prosecute yourself in jurisdictions which are contrary to the law that you're used to, which makes it an unconscionable contract. You plead the Fifth Amendment, okay? 14th Amendment don't have Fifth Amendment rights. I'm telling you, it's not a due process right, y'all. It's free. But a writ of prohibition was not always the last word. An ecclesiastical court can challenge a writ of prohibition with the competent writ of consultation, seeking return of a suit return of suit to its court. The writ of prohibition and consultation created a procedural mechanism for deciding the appropriate venue for resolution of particular controversy, but they did precious little to clarify the jurisdictional boundaries between the secular and sacred. The line between the two remained an oft-litigated source of controversy for centuries to come. Remember, the sacred are either old, the secular meaning the new. Okay? So we must understand that in order for us to receive what it is that we deserve, we must get due process of law. But for that, you need government. For that, you need the government. All right? So let's go to my closing case law. Supreme Court of Alabama. Ex parte First Exchange Bank class action. A petition for a writ of mandamus. And we know a petition for a writ of mandamus is a prerogative that a subject can petition the king to call the king in to speak on behalf of him. All right? As a subject, because that's the purpose of the king's bench, which is an itinerant court. It's a moving court. The king can't be in all places at one time. So he has his chancellor, which is the secretary for the king, which is now opt out for a president and attorney, what we call power attorney, attorney general. All right. This is in closing. Chief Justice for that thought. Once again, I want to give another shout out to Countess Searchy under her tutorage under Archbishop Belmont from the House of Belmont. You know, he's did a great job with preparing you for the moderating, you know what I'm saying, in lieu of your moderation for the Third Timothy English Church. And for that, you know, your reward is with me. All right. I feel your likes, and I'm really proud of you, you know, and like I said, I can say that for all those who attend to the king's business, you know what I'm saying? Because if you're not, then you're breaking the king's peace, right? So in closing, this is a Supreme Court review of a writ of mandamus petition in regards to late opposition to a writ of mandamus that was filed on behalf of the appellate, right? Supreme Court of Alabama, ex parte, First Bank of what's that? I forgot that terminology for ET, but I know it's a class action too. Anyway, Thomas, come on. Ex parte, First Bank, ETAL, which means class action petition of writ of mandamus. Anyway, Thomas Henry and Dollar Henry versus First Exchange Bank, ETAL. This is all about a mortgage, okay? We know a mortgage is given based off of an agreeable contract that's made between a borrower and a lender, or a contract, creditor, or a borrower. And this mortgage is deal what we call feudal tenure. We know feudal tenure deals with real estate by way of an instrument conveying that real estate by way of the grantor to the grantee. All right. We know that's not an instrument of ownership, it's an instrument of prescription, or what we call the non-possessory use, and the property that you don't possess. All right. You can never own it because the land belongs to the crown. All right. You only can use it. All right. That's all that instrument that you owe is an instrument of conveyance. All right. Because when you check or trace the chain of title, it will go back to the crown. Petition denied without an opinion. No memorandum, no whatsoever. Nothing to justify their order. All right? When a petition should be a right, to them it's discretionary, especially when you start hitting on something you're not supposed to be talking about. All right? If you don't believe me, read Billings versus Harris. No, not Billings versus Harris. What is it? What's that? Ward versus Scott. Actually, Villains versus Harris. Yeah. A city cop tried to blow the whistle on its preceding officers, and the Supreme Court Chief Judge Vanderbilt of 1947 revamp of the 1947 Constitution said, "Look, you one of us. Ain't no way in the heck you're gonna use the king's prerogative when we just stole the or stripped the king of prerogatives in the 1947 Constitution, which I was a party to by way of Alfred Driscoll, the governor, under his authority. So how the heck you gonna try to blow our spot up as a whistleblower when you work for us? You under contract, all right? You don't even get a right to a trial by jury on matters such as this. Read that case law, Billings versus Harris. Chief Justice Moore concurs with the decision of the court to deny the petition for a writ of mandamus. I write especially to explain my reason for denying the petition. The petitioner's delay in moving to strike the demand for a trial by jury and the unconstitutionality of pre-dispute contractual jury waiver as a violation of the right to a jury trial. Contractual jury waiver. Contractual jury waiver. When you get these tickets and go into these courts, these tickets are contractual agreements which are unconscionable. Why? Because you're on the receiving end of it. All right? Which is the unequal bargaining power, which makes it unconscionable, which under Section 2-302, as well as under the 2A 2-302 on the federal level, you have the right in lieu of any commercial setting to question any contract where you are at the receiving end, and when it puts you on, makes you subject to the rest by way of undue influence, which is a psychological mental control over as assuming that you're actually doing something wrong. When we're reading that, what we're doing is not wrong. All right? If I am saying something wrong, it ain't for that judge to decide. It ain't for that prosecutor to decide. It's for not for that jury to decide. It's for a jury of your own pedigree. All right? That's the supreme law of the land. That's the contract clause. That's the agreement that we made as creditors. All right? How? I'm about to prove it. I concur with the decision of the court to deny petition for the writ of mandamus. I write special to explain my reason for denying the petition. The petition delayed in moving forward to strike the demand for a jury trial, and two, the unconstitutionality of the pre-dispute contractual jury waiver as violating the rights to a jury trial. Delay in moving to strike jury demand. First Exchange Bank, the one who gave the mortgage, and Dan Thomas, the defendant below, the petitioner seeks a writ of mandamus directing the trial court to enter an order striking the jury demand of Thomas Henry Darley and Darley Henry, the plaintiffs below, which will be the appellant. Fact and procedural history on November 18, 2008. This is a 2012, what year is this? Okay. 2013, 2014. All right. On November 18, 2008, the Henry executed a real estate mortgage, the mortgage in favor of the First Exchange Bank of Brewton, Alabama, a division of the Farmers Exchange Bank. The mortgage contains the following provisions: waiver of the jury trial. To the extent not prohibition by law, mortgagors and lenders knowingly may have to a trial by jury with respect to any litigation arising from the secured debt or any other agreement executed in conjunction with the evidence of a debt in this mortgage. Mortgager and lender each acknowledge that this section has either been brought to the attention of each party legal counsel or to each party had the opportunity to do so on your own, i.e., be able to read or write or interpret contract law. Because I already tell you from the agreement which was presented before the court that you are a debtor in the matter. All right? And you waive your right to a trial by jury in lieu of the debt that you owe. Why? Because they're the creditor and you can't say nothing about it. And the court of law is going to justify it. Why? Because the law denies you what? A trial by jury. The judge don't supposed to be decided on any fact of the matter. His job is to decide on the law that's being applied and the jurisdiction of how it obtains it based off the parties at hand. All right? So it automatically becomes the diversity of jurisdiction as well as a violation of your civil rights. And when I say civil rights, I'm not talking about rights that's described by the 14th Amendment. We're talking about rights that descend from the Magna Carta as English people under the common law of England, as Smith, Alabama states, that all the states in the Union adopted the common law of England, which must be looked at in light of the history of the common law as prescribed as a local law, their municipal law. Smith versus Alabama, please look at that case. Okay, let me just, I gotta go here. That's number doing force the ether and magnetic poles is going to blow your mind. As you can see here, this is a real estate book from New Jersey, right? Real estate book. They talking about mortgages, all right? So it ain't dealing with personal property. It's dealing with tangible. It's not dealing with personal property or tangible property. It's dealing with real property. Real estate, tenure, okay? And you're not in a position to say anything because you're on the receiving end. You're not the mortgager. You're not the lender. You're not the creditor. You're the borrower. You're the debtor, okay? You must understand that. This is what you have. You're going to look it up. Pull out those briefcases. Pull out those, what you call those boxes that you have. But they keep, security boxes that you have. Because this is all you got. A bargain and sales deed. If it ain't that, it's a warranty deed. That's what you got. That's all you got. All right? And now that you know that, that's all you got, that you only got a right of conveyance in the use of the property, and now knowing that you actually own the property as an heir, how did you get due process of law? Because church and state has been separated, so you have no remedy at law. The English do. Why? Because you have the right to due process of law, right? A right to a trial by a jury. In the court of law, these matters are heard in probate court. You know what I'm saying? Even if the matters deal with property, you still got the right to be heard by your own peers, all right? In regards to that property. Let's prove it. In closing, on September 2020, on September 22nd, 2010, the Henry sued the petitioner demanding a jury trial and alleging, among other things, fraud. You hear this? This is what y'all all should be alleging, right? But you ain't gonna get no jury trial, right? You ain't gonna get no jury. The English will. With this case, you're gonna get it, all right? It's gonna prove you get it because we created jury trial. Yes, Godfrey V Canavan Jew, son of folk, ruler of Jerusalem, created the jury trial for all the English heirs and successors, all right? On September 2010, the Henry sued the petitioner demanding a jury trial, alleging, among other things, fraud, breach of contract, breach of fiduciary duty. All right? The petitioner filed an answer and a counterclaim on November 1st, 2020, but did not challenge the jury demand on mention of the jury waiver clause and mortgage. So he filed a complaint, but never mentioned anything about the waiver of the jury trial in the actual agreement that he filed a complaint on based upon fraud, breach of contract, breach of fiduciary duty. You overlook or oversight. All right, you gotta read those contracts. The trial court, after holding the hearing on June 7, 2012, denied the motion without comment. The petitioners then filed their petition for a writ of mandamus, directing the trial court to enter an order striking Henry's jury demand. The court had previously allowed mandamus reviews of orders to address the availability of a jury trial. Mandamus is an appropriate remedy where the availability of the jury trial is at issue. All right? Granted the petition for a writ of mandamus and reversing the jury court order denying motion to strike jury demand. Standard review. Mandamus is a drastic and extraordinary writ to be issued only where there is clear legal right in the petitioner to order so. You hear that? A clear legal right. An imperative duty upon the respondent to perform, accompanied by refusal to do so. The lack of another adequate remedy properly invoke jurisdiction of the court. All right. So we know automatically that you can't have a right amendment because one is extraordinary. You must have a legal cause to raise it as a petitioner, and you can't because only an English person has the right as a petitioner right as an heir. Let's prove this. Discussion. Validity of the jury trial. The petitioner urged, and the Henrys do not contest, that the jury waiver clause in the mortgage was facially enforceable. All right? Because of that contract oversight clause that he failed to realize. Okay? He was out of time. Let's go to the meeting. In closing, so I wasted time without the procedural history because this was not my reading. It was both. He was in error. Let's see why he was in error. Majority of the case on this standard of review arises with both parties being in error, and in the event of filing a complaint on such a claim. Let's see why. So in conclusion of the complaint, in conclusion of this case, this lecture, the conclusion in regards to writ of mandamus, in regards to fraud that was being done by the mortgage company, in regards to the unconscionable contract that he fell victim to, which all you fall victim to and will continue to fall victim to as a result of your legal status as not being considered citizens. All right? It says, because of their lengthy delay and movement to strike the Henry's jury demand, the petitioner, in my view, are not entitled to a writ of mandamus ordering the trial court to strike the Henry jury's demand. Strike the Henry's jury demand. That's the origin of jury demand. 2. Unconstitutionality of pre-dispute jury waiver. A right to jury trial by jury, the historical bill. America inherited its high regard for the jury from England, where it has become, in Sir William Blackstone's word, the glory of English law that has so great an advantage over others in regulating civil property. You hear that? Commentaries on the laws of England. According to Sir Frederick Pollock and Frederick William Maitland, this is a 2013-2014 case in Alabama and Supreme Court. The essence of the jury, if we use the term jury, I'm sorry. Can you see, Countess? Thank you. All right. So we see in this case, in regards to failure to strike request to deny for a writ of mandamus, which was not the reason for the denial of writ of mandamus. They only denied it, uh, denied, denied it as a result of the real intentions of him trying to use something that didn't rightfully belong to them, because he was trying to expose the mortgage agreement when the mortgage agreement is allowed as a result of the eminence of power that the mortgager is allowed to do by way of the power granted by the state. Okay? A mortgage company who allows property or buys property, who sells property or buys property, has to have a license in the first place. Okay? You got to get a license. Where does the license come from? The state. Real estate license. Okay, so they all in on it. So don't try to go blow up the spot, because you're going to wind up losing out. All right? The only person who can blow up their spot is the English nation. How? Let's prove it. The right to a trial by jury, a historical bill. America inherited its high regard for the jury from England, where it had become, in Sir William Blackstone's words, the glory of the English law that has so great an advantage over others in regulating civil property. So when we have a problem with our property, we're supposed to have a trial by jury. All right? Majority of you don't. It's usually an open and shut case. All right? It's open and shut case. Don't worry about it. I got you. Usually an open and shut case. Commentaries of the laws of England. According to Sir Frederick Pollock and Frederick William Maitland, the essence of the jury, if we use the term jury in the widest sense that can be given to it, seems to be this: a body of neighbors is summoned by some public officer to give upon oath a true answer to some question. The history of English law before the time of Edward I. You hear that? Of the Plantagenet crown. Through the War of the Roses. Not only Edward I, let's see who else they mentioned. Pollock and Maitland discusses how the jury system arrived in Britain. The English jury has been so highly prized by Englishmen and women as English people, so often copied by foreigners. Did y'all hear that? By foreigners, that its origin has been sought in many different directions. At the present day, however, there can be very little doubt as to the quarter to which we ought to look. We must look to the Frankish Inquisitor, the prerogative rights of the Frankish king. That's a lie, because the Frankish kings were the Carolingians and Merovingians who stole it from the Plantagenet crown through the wars of the Carolingians and the Plantagenets, called the Capitan Plantagenet War. Okay? Let's look that up before we read on. Because now the judge is trying to lie. They're trying to lie. Now we know Frederick Douglass said he was Anglo-Saxon fraternity. All right? Plantagenet are an extension of the Anglo-Saxons through the marriage of Matilda, Empress Matilda, the Roman Empress, who was the daughter of Matilda of Scotland, Margaret of Scotland, who was Margaret of Wessex, who married Malcolm of Scotland, who was of one of the kings of the Kingdom of Alba. All right? Capitan Plantagenet War. Capital Plantagenet robbery was a series of conflicts and disputes that covered a period of 100 years, during which the House of Capet, rulers of the Kingdom of France, fought the House of Plantagenet, also known as the House of Anjou, rulers of the Kingdom of England over the Plantagenet-held Angevin Empire, which at its peak covered around half of the territory within France. Some history referred to these series of events as the First 100-Year War. Okay? There you go, y'all. That's the origin of it. We've been war with the Frankish king forever, right? Let's just clear this up once and for all. Frankish. You got the Angevin, which was ruling France, and then you got the Frankish, who was trying to overthrow France. Let's see who these are. Because this extends down to Louisiana. All right? Francis I of from the House of Capet. This is his origin. Kingdom of France. All right? The Kingdom of France, Middle French, is a historical name of umbrella term given various political entities of France in medieval and early modern period. It was one of the most powerful states Europe since the High Middle Ages. It was also early colonial power with colonies in Asia, Africa, and largest being New France and North America. You hear that? Did y'all hear that? The Kingdom of France was descended directly from the Western Frankish realm of the Carolingian Empire. They're not talking about us, y'all. I need y'all to know that. All right? The Plantagenet crown, which we'll go back to the case, was descendants of English, which were warm with the Carolingian Merovingian dynasty, who descended down from Clovis I. All right? Clovis I was a Frankish Northman, right? And there's a culture over in North America called the Clovis culture. So how in the hell could Clovis the first be over in Europe, but have a Clovis culture here in North America, because that's where the name derives from? All right? The Carolingian Empire descended from the Merovingian Empire, and they never claimed to be descendants of the Anglo-Saxon, who descended from God. Let's prove it. Oh, here we go. Carolingian Empire. Preceded by who? The Merovingian dynasty. You hear that? The Merovingian dynasty. So let's click that. Merovingian dynasty. The dynastic name, medieval Latin, Merovingi or Merovingi, son of Merovach, derives from the unattested Frankish, which is also Scottish, former kingdom of attested Old English, Merovingi, however you pronounce it, which is the final ing. Ing is no different than the word son, okay? Or Mick, all right? It's a patronymic name. Being a typical dramatic patronymic suffix, the name derives from Salian king Merovach, who is a center of many legends. Unlike the Anglo-Saxon royal genealogy, apparently the founding fathers were a part of the genealogies because their nation was based off naturalization, not nationalization, because they would come from a nation that has a national genealogy, ethnicity that they are associated with. They didn't associate with based off the Nationalist Act of 1790. Okay? And that means that they're affiliated with the Merovingian or the Frankish dynasties who were warm with the Plantagenet crown, who were descendant of the Anglo-Saxon, as I said, it was over the marriage between Godfrey V, Count of Anjou, married to Matilda, the daughter of Margaret of Scotland, or Margaret of Wessex, the daughter of Edward the Elder. Okay? the son of Æthelstan ready, the son of our Jesus Christ, i.e. King Edgar the Peaceful, which was just seen in the 2020 case law in the 5th District Court. It says, unlike the Anglo-Saxon royal genealogy, the Varangians never claimed descent from God, nor is there any evidence that they were regarded as sacred. Did y'all hear that? Did you hear that? So the Anglo-Saxons are not Frankish, nor are the Frankish Anglo-Saxons, as referring to this case law that we're making reference to. The English jury had been so highly prized by Englishmen, so often copied by foreigners, that its origin has been sought in many different directions. At the present day, however, there can be very little doubt as to the quarter to which we ought to look. We must look to the Frankish Inquisisto, the prerogative rights of the Frankish king. Inquisisto means inquisition, okay? Inquisition. On who? The plantation crown. How we know? Let's read. It says, in the 9th century in England, before the reign of King Alfred the Great, a king of Wessex, all right? Why King Alfred means wise elf. Witten, wise elf. What's that, Sir George? Yes, sir. Acetone, acetone means noble stone, and Alfred the Great means wise elf, okay? Alfred, wise elf. The Danes gradually began to incorporate the jury model into the English legal system. The Normans refined and revised this model. So we see the Danes invaded England, i.e. those Norsemen, i.e. those Frankish, i.e. those Carolingian Merovingians who never claimed to be descendants of God like the Anglo-Saxons, okay? A Danish town in England often had as its principal officers 12 hereditary lawmen. The Danes introduced the habit of making committees among the freemen in court, which perhaps made England favorable ground for the future growth for the jury system out of Frankish custom introduced later by Normans. Okay, Normans were under William the Conqueror, who invaded England. Okay, William the Conqueror's name was William the Bastard. His son Henry I was originally supposed to have his son marry Empress Margaret, which was the daughter of Godfrey the fifth Count of Anjou father, Fulk V. Yes, Margaret of Anjou was supposed to, was it Mary of Anjou or Margaret of Anjou, was supposed to marry Henry I's son, what was his name? What was his name? It was called the Anarchy of the White Ship. William Adeline, I think it's William Adeline. I could be wrong though. Yeah, William Adeline, that's his name. Read the Anarchy or the White Ship, or look up the Treaty of Westminster of 1153. The Treaty of Westminster of 1153, all right? So let's move forward. Oh, damn, sorry. Thank you, Countess. You good? Oh, my bad, I had to scroll. All right, let me move forward. Here we go. A short history of England in the 2013, 2014. All right. The Supreme Court of Alabama is giving us a shortened history of England as English people. Right. And look where the notation comes from. Of note in the present case is that during the 12th century, Godfrey of Anjou, also known as Godfrey V or Godfrey Plantagenet, implemented the jury model for the important civil cases. Howard J. Berman, Law of Revolution, states that the jury model, the first arose in England as a right, not in criminal cases, but in civil cases. The regular use of a small group of neighbors to decide cases before royal judges first emerged in English law in civil cases, and only 2 generations later was it taken into criminal court. The civil jury system expanded and developed under the rule of Godfrey of Anjou, son of Henry II. Henry's grand assize enabled a man whose right to property and land was challenged to claim a trial by a jury. If such were his choice, 12 neighbors who knew the facts were to testify before the king's justices as to which party had a better right to the land, y'all. This is in 2013, 2014. 2013, 2014. Y'all hear me? Can we get an applause, y'all? Can we get applause? Somebody give an applause. Oh, I'm bugging with this controller. I'm bugging with this controller. Writing during the reign of Henry II, the juror for Randolph de Glenville describes procedures by which a plaintiff in a civil trial regarding property would seek a writ of assize to initiate the lawsuit, at which point the defendant would pray another writ in order that 4 lawful knights of the county, i.e. citizens and of the percentages, might elect 12 lawful knights from the same percentage who should say, because right now we're on the crusade, so y'all consider knights, upon their oaths, which of the litigating parties have a greater right to the land in question. So this is why I need y'all. English subjects. You can't do it without English subjects, y'all. Right? You can't do it. A treatise on the laws and customs of the Kingdom of England, composed in the time of King Henry II, being re-resurrected in the 21st century. They ain't talking about Frankish Norsemen. They ain't talking, oh, God. These precedents, established during the reign of Henry II, enabled the jury model to flourish in England for centuries to come. In the course of the later Middle Ages, the jury were gradually transformed from givers of sworn evidence to judges of the evidence of others. In the 13th century, when King John imposed high taxes on the barons and landowners, and then used the revenue to fight expensive wars against France, i.e. the Frankish, as well as to fund a campaign against the church in Rome, he was fighting on both fronts, y'all, for us. All right, and these were young people. All right, young people against France, as well as to fund against the Church of Rome. A group of feudal barons forced him in 1215 to affix his great seal to the Magna Carta, which guaranteed a right to a trial by jury in both civil and criminal matters. Nullius labor homo capiata bell and principator artera desitior aut atelitor aut elgator aut elgulgor parcel modo destructio nec support umbo ambiguous. I'm gonna stop. Archbishop, I need you, bro. I need you. I'm not gonna continue on with that. Nevertheless, the command or official seal of the king was not necessary for the civil jury trial to flourish as a widespread practice, because even commercial courts in the 13th century and 14th century, operating pursuant to the ancient law of merchant, i.e. commercial setting, recognized the right to a jury trial and took pains to organize juries made up of citizens of different nations. Trials involving both a merchant, stranger, and Englishmen require a mixed jury composed half of foreigners and half of English subjects. Appeals could be taken to the Chancellor and the King's Council. By the 15th century, the jury trial became a touchstone of the English legal system and will continue in roughly the same from until the present era. In the 15th century, the jury system, more or less, as we know now have it, was that no freeman should be arrested. We're talking about search and seizures, Brown versus New York. All right, search and seizures are unlawful for English people. No free man should be arrested or imprisoned or deprived of his freehold or his liberties or free customs or be outlawed or exiled or in any manner destroyed, harmed, nor will we, the king, proceed against him, nor send anyone against him by force of arms, unless according to that is in execution of the sentence of his peers, or as the case may require, the common law of England, as it was at the time of the Magna Carta. Did y'all hear that? All right? Law is law. Already the boast of Englishmen proudly contrasts the Chief Justice Fortescue with French procedures where torture was freely used. Moreover, the jury became even more important in England when the volume of litigation soared in the 16th and in the 17th century. In closing, the civil jury in America seen from an unprecedented history. Alan McFarlane, Reconstructing Historical Community, for evidence that between 1589 and 1593, more than 200 legal actions went before juries. And one of the most famous cases in England during the 17th century, a jury of 12 acquitted Quaker William Penn and William Med, who had been prosecuted for preaching on public streets, i.e., what we call Southern Baptist Commission. That's it. Yeah, that's enough. So in closing, State Exwell Baxley versus Starbridge. Court of Criminal Appeals in Alabama, 1974. What does it say? Perhaps, this is read a little bit. The salient features of a grand jury procedure is secrecy. A grand jury may investigate, but in the absence of a statute, it may not compile records. It was held that a person criticized but not indicted was entitled to have a so-called grand jury report expunged. The grand jury either indicted, recommends impeachment, or does nothing of the record, put up or shut up. Did y'all hear that? Perhaps this was not always so in the plantation England, when the Norman kings were installing their version of feudalism, making all freemen oaths bound to the sovereign, as well as the lord from whom the subjects held land. However, by the time of the settlement of America, an English grand jury was essentially the body we know today. All right? So there you have it, brothers and sisters, from your king, King Clifford Jefferson of Senator Godfrey the Fifth Count of Banjo. You are sitting before the king's bench. You're hearing the king's law, and you're hearing the king's requirement, as prescribed by the king's ancestors. So with that, I hope everything that was clear and fruitful for you. We're calling on all brothers and sisters to come out of that iniquity that you're now under as a result of that iniquity that was put on you by these so-called churches that don't have a clue about the English Church of England, which we need for our earthly and divine salvation. So once again, I greet you on behalf of my queen, Sister Goverson from the House of Goverson, as well as my moderators, Countess Searchy and Archbishop Belmont from the House of Obama, as well as called Judah, Geronimo Bay Murphy from the House of Murphy. And I love you all dearly. All right. Like I said, many are called, but few are chosen. And the time is here. All right. Time waits for no one. And with that, that's all says. Peace.